Ellsberg's leak of the Pentagon Papers to the press was extremely historically significant because it informed the public about the U.S. involvement in the Vietnam War, which obviously has intense historical and social significance that even resonates through to today.
I'm Justin Silverman of the New England First Amendment Coalition. A quick reminder to join us each month for our 30-minute skills classes. We're providing short, practical lessons on data cleaning, how to respond to subpoenas, how women journalists can protect themselves from online harassment, among many other important topics. You can register for upcoming classes and find previous lessons at NEFAC.org. I'm here today with Lin Weeks, a staff attorney at the Reporters Committee for Freedom of the Press. Thanks for joining us, Lin.
Yeah, thank you for having me.
Lin, you and your colleagues at the Reporters Committee recently filed an amicus brief on behalf of NEFAC and other media organizations arguing for the release of certain grand jury testimony. This is an interesting case that goes back to the Vietnam War and the Pentagon Papers. But before I have you fill us all in on the backstory of this case, can you first explain to us what a grand jury is and why testimony given during these proceedings are typically kept secret?
Sure. So a grand jury is a body convened of members of the public, which are presented evidence by the government as it starts a criminal prosecution, and the grand jury then determines whether or not to indict the person that is the target of the government's prosecution, which will then proceeds into the rest of the criminal case.
Okay, and during these proceedings, all the testimony that's given, the evidence that's provided leading up to a possible prosecution is typically kept secret. Why is that? Aren't our courts typically open? Isn't there a presumption of openness? Why the secrecy specifically?
Sure. So there are a few reasons that grand jury proceedings are typically kept secret. So during the proceedings, the government calls witnesses who present testimony to the grand jury. And so the proceedings are typically kept secret so that the members of the grand jury can deliberate without sort of worrying about retribution. If they're going to return an indictment, they don't have to worry about potential for bribery or witness tampering, anything like that. And it also prevents the potential indictees from fleeing, and it also, if no indictment is returned, it keeping the proceeding secret protects the reputation of an innocent person from suffering the effects of the public knowing that they were the target of this criminal investigation.
Good. So as a general matter, there are some compelling reasons why grand jury testimony should be secret, at least in the short term.
At least in the short term, and at least in a general matter, sure.
Great. So let's get back to the case at hand. Lepore v. United States. This is the case that's ongoing, that the Reporters Committee filed the amicus brief on behalf of NEFAC and other amici. How did this case come to be? What's the backstory here? So
in 1969, Daniel Ellsberg began photocopying what would later become known as the Pentagon Report, which was a massive report commissioned by the Secretary of Defense, sort of cataloging U.S. involvement in Vietnam. And among other things, the report made clear that the executive branch of the military had covered up from Congress and the public the extent of the U.S. military involvement in the war, the prospect for success for various actions that the military had undertaken in Vietnam, and as well the motivations for various actions that the military had undertaken in Vietnam. So Ellsberg begins photocopying this report, and in 1971, it's obtained by the New York Times and a number of other news outlets. And the Times publishes the first portion of that report in June 1971. But before the Times publishes that first portion, the government has begun investigating Ellsberg's copying and subsequent leak of this report. And so to do that, they convened two grand juries, they convened a grand jury in Los Angeles, which investigated and returned charges of theft and espionage for Ellsberg and his colleague, whose name was Anthony Rousseau. And they also convened a grand jury in Boston, about which less is known. It's unclear a little bit what the Boston grand jury was convened to investigate. Reports at the time indicate that it might have been convened to investigate Neil Sheehan, who was the Times reporter that obtained the report from Ellsberg. So in the Los Angeles grand jury, as I mentioned, charges were returned for Ellsberg and Rousseau of theft and espionage. Rousseau refused to testify, and so he went to jail for contempt of court. Ellsberg's case proceeded to trial, but the charges against him and Rousseau were later dropped when it came to light that the government had committed prosecutorial misconduct, including illegal wiretapping and breaking into Ellsberg's psychologist's office. But meanwhile, the Boston grand jury had proceeded, and the first Boston grand jury was disbanded without returning any charges, and a second grand jury was convened in Boston, also in 1971. So fast forward to 2018. Jill Lepore, who's a historian and a writer for the New Yorker, is researching a book on a company called the Simulmatics Corporation, and in particular, one employee of the Simulmatics Corporation named Samuel Popkin. And through her research, Professor Lepore determines that she needs to see these materials from the Boston grand jury. Samuel Popkin was called as a witness for this grand jury in Boston. So the first step she took was, so she determines that the records from this grand jury are being kept at the National Archive in Boston. So the first step she took was to try a FOIA request for the grand jury records. That FOIA request was denied. And at that point, I think Professor Lepore linked up with the Yale Access Clinic, who filed a petition with the district court in Massachusetts, asking them to disclose those grand jury records.
But we already know from your introduction to grand juries that this type of testimony is typically kept secret, and usually for pretty good reasons. So what are the arguments that you made on behalf of NEFAC and other amici in the brief to convince the court that despite that history, despite those compelling reasons, this testimony should be released and we should be able to benefit from its research?
Sure. Well, you're right. So as I mentioned, grand jury records are traditionally kept secret, but at the same time, there's also a long tradition of what's called the court's inherent supervisory authority over grand jury and their materials. So what that boils down to is that in appropriate circumstances, as a historical matter, district courts have been able to disclose those grand jury records when they found it to be appropriate. And so there was a case in the late 90s in the Second Circuit involving a historian whose last name was Craig. So I'll refer to this case as the Craig case, where the Second Circuit took a look at the federal rules of criminal procedure and the history of how those rules were put into place. And they took a look at the tradition of grand rural secrecy, and they determined that what district courts should do is look at a list of what they called non-exhaustive factors to determine when it was appropriate to release grand jury records. And so some of these factors that the Second Circuit directed district courts to look at were who is seeking the grand jury records, why are the records being sought, are the target of the grand jury investigation and the witnesses who presented in front of the grand jury still alive, and do they oppose disclosure of the records, and as well have any of the materials that for disclosure is being sought, have they been previously disclosed? Are they already partially public? And so the argument that Professor Lepore made was that these grand jury records are so historically significant, given the history of the Pentagon Papers, and there is no party that opposed the disclosure of these records, and enough time had passed, almost 50 years at that point since the grand jury had been convened, that it would be appropriate for the grand jury records to be released in this case. The government opposed Professor Lepore's petition on the grounds that Federal Rule of Criminal Procedure 6E sort of displaced district courts' inherent authority and provided an exhaustive list of all the circumstances in which grand jury records could be disclosed, which the government argued did not include to the public for historically significant matters like this one. So that was the argument, sort of, that the two sides of the argument that the district court looked at.
Great, thank you. So what will a favorable ruling look like in this case? Will it simply be just the release of this testimony? Will favorable ruling have broader implications, perhaps create some kind of precedent for similar cases moving forward? Just how narrow or broad of a ruling are we looking for here? Sure.
So I should say that the district court did find for Professor Lepore. It found that release of these records was appropriate, that it did have the inherent supervisory authority to disclose the records. So this case is now on appeal at the First Circuit. And the implications, there are a few implications. I think as a general matter, I think it's important that courts, I think as a general matter, it's important that courts find that district courts have this inherent authority to release grand jury records in appropriate circumstances. You can see with a case like this one, with historically significant or socially significant grand jury proceedings, it's very important that the public be made as fully aware, be given the full context for a historically significant event like this one. In addition to that, these records specifically deal with the government's use of the Espionage Act to prosecute a leak of government information to the press. And so that's of particular importance, both historically and today, because government use of the Espionage Act has increased significantly over the past 10 years or so. The Espionage Act was put into place during World War I to prevent spying on behalf of or by foreign governments. And it was largely used that way until about 2009, with very few exceptions. This Espionage Act prosecution of Ellsberg and Rousseau being one of them. But in the last 10 years, we've seen more and more use of the Espionage Act to go after people that disclose classified government information to the press rather than foreign governments. And that's concerning. That distinction is very important because, you're talking about a distinction between people who are looking to harm the U.S. by disclosing government information to, foreign entities, foreign states, versus people who are looking to sort of serve the public interest by disclosing information to the press that the government would prefer to have covered up.
Got it. So all of these are tremendously important issues, and I think any attorney or journalist in particular that's hearing you speak right now, a lot of red flags are popping up, a lot of various concerns that we immediately identify as relevant to the work that journalists do, relevant to the public's right to know. But as we wrap up here, if you could for us, for the sake of those that don't work in newsrooms, don't spend any time in courts, may never have heard of the Pentagon Papers before, Daniel Ellsberg, why is this case so important? Why is it relevant to them and their lives? Can you put in, plain terms for us why this case is, why anyone outside of newsrooms and courtrooms should pay attention to this case?
So I think this is important because of the intense historical and public interest in the disclosure of the Pentagon Papers. Ellsberg's leak of the Pentagon Papers to the press was extremely historically significant because it informed the public about the U.S. involvement in the Vietnam War, which obviously has intense historical and social significance that even resonates through to today. In addition to that, the Espionage Act angle to this case, the fact that leakers of government information are now being prosecuted using this law designed to prevent leaks to foreign governments, is very significant as well, because there's a chilling effect on people that would bring forth important public information to the press that would inform the public's knowledge of actions that the government is undertaking.
Great, thank you. I appreciate that. Oftentimes, during these interviews, we talk about matters of freedom of information, press issues, legal concerns. But I think it's so important for everyone to understand, regardless of what their backgrounds are, that this is an important case for them too, and their right to know about all of these issues, particularly when they have such historical significance. So, Lin, thank you for taking the time today to really walk us through all of these issues in this fascinating case and give us a quick history lesson on all of the circumstances that have led up over the last 50 years or so to where we are right now. Greatly appreciate your time, and thank you again for all of the work that you do at the Reporters Committee.
Yeah, thank you so much for having me.